Sorry to keep you waiting, Mr. Bowers.
No, not at all. As my lords and my lady appreciate, we take the alternative points that temporary means short-term, an approach which was eschewed by Mr. Justice Singh, as he then was in Moran. But if we're wrong on that, the correct approach is even so to look at the purpose and nature of the work, because there was a refinement of the principle in Brooknight and Angard. Accordingly, I propose to address you on 4 bases. Firstly, a brief recitation of the key facts. Secondly, the 3 EAT cases. Thirdly, the reasoning of the tribunal in our case, and then to make submissions on grounds 1 and 2 together. Mr. Sheridan will address you on ground 3. You have been taken...
ground 3 was.
It's that in any event, this is not a temporary...
Yes, I see. As it were, all the facts.
Matter, yeah. So, if I could...
Before you go any further, just... This won't come as a complete surprise to you, I suspect. Well, it certainly won't. I've phrased it this morning, but you may have seen it coming from the skeletons. On the point on which you're not addressing us, it is implicit in MCG's submissions that at least one possibility is that if they're not the employer, Ryanair are. This is for the purpose of the claim under the CAWTR. Now, that doesn't worry you in these proceedings because your their claim has been brought against you for reasons which will no doubt be elucidated by Mr. Ford. But it might worry you in other proceedings.
Yes, still to come.
Still to come. Can you give us any help on the proposition, which is hard to avoid considering in considering the dispute on the MCG claim, that if they're not the employer, Ryanair is?
Well, we say that it simply doesn't arise because experienced solicitors in this case chose not to bring the claims against Ryanair. The Employment Tribunal hasn't dealt with it, and the Employment Appeals Tribunal hasn't either.
No, I see that. And in one sense, for that reason, which I quite understand, anything we would say would in the first place be obiter, and in the second place would be, as it were, you would say dangerously obiter, because we haven't got any of the findings, or we have got some findings, but we may not have all the findings that are relevant to that question.
Well, they're not directed to that question.
Exactly.
There may be some stray findings that are directed to other matters.
I get all that, but you will appreciate that in considering the issues of principle raised by MCG about who is the employer, it will be difficult to avoid, at least by implication, and even if certainly not as a matter of binding decision on anyone, considering whether the end user or operator is the employer. You're perfectly entitled to say, and if you do, we will respect it, that you are not going to say anything about it, and we will leave and be have to left for another day, given we can't say anything binding about it here.
Yes.
But I just, at the moment, I don't know, we haven't written it yet, you may find things there which at least put you in the firing line for another claim. And I just wanted to say that if you chose to address us, within, at least to some extent, or give us some steers, the opportunity is there. Well, I absolutely respect the formal and understandable position that you have taken.
Perhaps I could just add, if I may, before you answer, although my Lord says, no doubt rightly, that anything we might say would be obiter. Ultimately, it is not for us to decide which parts of our judgment would be obiter. That would be for decision by any subsequent court deciding what was essential to our reasoning.
Yes. Well, I meet you halfway, my lord, in this sense.
Yeah, you don't need to do it now either. But anyway, yes, say what you want to say.
There are things done by MCG and recorded in the tribunal's decision. If I could give you the paragraph numbers, they're these: 28, 33, 43.
Which was the first one?
28,
28, 33, 43.
43, 55, 61, 75, 73, and 85.
So, did you mean 73?
Yes, so I did mean 73.
No, that's fine.
Out of order,
It was meant to be 83. Yeah, and 85. Yes.
And we submit that there is sufficient in there for the Court of Appeal not to decide that any employment is by Ryanair. We also say it would be quite wrong to do so even on an obiter basis when the case is being put by Mr. Brown. Not that he has to show that somebody else is an employer. All he has to do is to show that his clients are not. That is the issue before you, not a conclusion, which even if obiter would clearly have great weight in future cases when it hasn't been argued below. Nor
Well, I do see all that, but I'm sure you see our difficulty. It is artificial, frankly, to consider whether one person, the person who's been sued, is the employer, with all due caution, considering what the position would be if they weren't.
Well, in our submission, since a decision was taken by Mr. Lutz, it may not be a decision that's taken by other pilots in this series, not to sue Ryanair, that we would say is the end of the matter.
Yes, no, that's what I regarded as your formal position, which I respect and understand. But I can't give you a guarantee that we will not say things with all due caution that you may not like.
No, I fully understand, and I've sought to meet it in the way that I can, given the time.
No, fair enough.
Afforded. So may I take you to aspects of the facts that we say are relevant to the question of whether this was temporary employment. And if I may lift from behind the veil that Mr. Brown put it under, the terms and conditions of contract, which are at supplementary bundle tab 11.
Yeah.
This is the McGinley, Dishworth, Port and Lutz contract.
Well, strictly speaking, not a Lutz contract, but
A company, as company representative.
As company representative, they're not as party. But in practice, everyone is proceeding on the basis that that was a fiction.
We don't take any point on that on appeal. So you've got the definitions of the company representative. You've got the hirer as Ryanair. You have the term specified in Schedule 1, which is 5 years. You have the work described in Schedule 1. You have on page 54 at paragraph J.
you'll take us to Schedule 1 in a minute, are you?
Yes, I will. I'll do it
so-
in sequence, if I may.
Yeah, no, of course, certainly.
Service company will make company representative, and it's a substitute point that we don't take further, available to perform the work on behalf of the contractor for the hirer from the commencement date. And the fees are set out on page 56 at 2A. The contractor will pay the service company sum as listed in Schedule 1. And then I don't need anything before Schedule 1, which is at page 60, where we see the term being for a period of 5 years, and then the minimum hours commitment at 3A, where the company representative has been providing services under this agreement for at least 12 months is available to work. The contractor will provide a minimum of 450 flying hours per annum during the period from the 1st of April. So it is a 5-year term, and I'll develop later why, unfortunately, we diverge from Mr. Brown's submission that the true place to look is the contract between the Ryanair and MCG. We say it is...
So could we just say, and I may have... I forget whether I made this point about this contract or wrongly about the other contract, but there is actually a 3-month notice period, isn't there? Just before you get to the schedule, at clause 6 of the agreement itself.
Yes, the contractor or service company may terminate this contract by giving not less than 3 months.
Quite how that relates to the 5-year term, I don't know.
Well, it would presumably be to terminate before the end.
Yes, so it terminates by a fraction of time after 5 years, and 3 months' notice at any point up to then. Yeah, yeah. Well, I agree. That
would, I think, be the natural reading of it. Now, what is a very important finding when we look at the practice in this case, in other words, going beyond this contract itself, is the tribunal's decision that without exception, a contract pilot who wished it would be issued with a new 5-year contract. And we find that in the core bundle, tab 18, at page 293, please.
Did you say 293, did you say?
Page 293, paragraph 115.
1 second.
The judge says there was a fixed 5-year term. It was not indefinite. Also contained 3 months notice period. Expiry of 5 years. Any contracted pilot who remained was, without exception, issued with a new 5-year contract. Then says a succession of fixed terms is not indefinite. And there's a slightly less
They wouldn't be obliged to be, would they? This is a statement simply, presumably based on evidence about what happened in practice.
Yes, this is the practice. They were always, without exception,
Yes, I'm just getting my timings right. This would have been a non-issue until the end of 2016. So it would apply only to people who, assuming they were all on the same terms as we've just seen, between 2017 and when was his dismissal? Use the term loosely. 2019,
I think it was.
Yeah, so we're looking at a 2-year period we have no idea what the numbers are. We know most people, there is evidence, isn't there? Most people go before 5 years.
But that's the evidence. But the
isn't it also a finding?
It is a finding, yes.
Yes, so we don't actually know. Without exception might mean 2 or 3 people. We just don't know.
Well, in our submission, what's important is the expectation when Mr Lutz entered into the agreement on the 1st of February as to how long the period would be. It would be a 5-year period, but without exception, he would be...
Well, it's only if he asked and knew that.
So,
if we're talking about his expectation, that would only be if he asked and or knew from other sources that what had happened in the last year, because that's really all it would have been.
But I'm sorry, my lord.
I think I was going to ask the same question. Where is the finding that he had that expectation?
But there's no finding, but in terms of the actual practice, that is what happened. That is what would have happened had he not been dismissed, that anybody was, without exception, issued with a new 5-year contract. I can't take it any further than that. But paragraph 77 is a more equivocal statement, which is at page 284 earlier in the judgment. At the end of a contracted pilot's 5-year term, they're usually almost invariably offered a new 5-year term. No one is simply allowed to roll on past the 5-year point. And the third aspect of the facts I'd just like to draw your attention back to is that contractor pilots did not provide cover. They were integrated in the rostering on the same basis as the employed pilots. And we see that at paragraph 27 at 273 in the passage that Mr Brown has already taken you to. Originally, and one sees that in the MCG Ryanair contract, they were to cover 4 pilots at short notice, but later, and it says it's 7 lines from the bottom. However, by the time Mr Lutz came on board, the rostering was of all pilots employed and contracted on the same basis. The contracted pilots became even more integrated when Ryanair agreed that for seniority purposes...
I see that, but he wouldn't have an expectation that that would continue to be the case. Suppose there was a falling off in work.
Yeah.
The Ryanair would be within their rights, and so indeed would MCG, in saying, well, we've got to pay the employed pilots anyway, and therefore we will leave off the rosters, some, or depending on how bad the turn down was, all of the contracted pilots. Before we touch the earnings of the employed pilots. Well, that would be what you'd expect. That's the point of having 2 workforces. The fact that at a particular time there's full employment doesn't affect the nature of the relationship.
Well, but these contracted pilots were integrated so that for seniority purposes, all pilots were one pool. So
well, seniority is one thing, but in terms of actual availability of work, which is what I was asking about, integrated surely only means that at the time in question, they were all rostered for every roster. They weren't treated any differently. But that only suggests that Ryanair was jolly busy.
But I accept it's theoretically possible, but what we say we can rely on is that what actually happened was that without exception, they were offered a further 5 years, because this is an expanding airline and has been throughout. If I may go to the 3 EAT authorities.
I don't suppose it was for anybody whose 5 years expired in 2020, when planes weren't flying.
Well, of course, that's an issue that couldn't have been anticipated.
Yeah, but all sorts of things can be anticipated. Drops off for all sorts of reasons. Economic problems. Also, 5 years is a long time.
Yeah, 5 years, we say, in any event, is not temporary, of course, which is one of our central points. But before coming to the 3 EAT authorities, can I seek to categorise them in this way? That in Moran, you had cleaning contractors working at a specific place, Spondon, who were found to be permanent, deployed at the particular site for between 6 and 25 years. It was held that temporary was not short-term. They were held to be permanent. In Brooknight, the second case, the guards also had open-ended contracts. So they were not subject to a fixed term or condition of termination. But because there was contractual flexibility and they provided cover, they were found to be temporary. So in other words, the permanent nature of the contracts, the open-ended nature of them, did not lead to them being found to be permanent. Similarly, in Angard, which was, of course, the captured employment, the in-house employment agency of the post office, again, the contracts were open-ended, not fixed term, not terminable on condition, but they were found to be temporary because they were 0 hours contracts. And what we say is that cases 2 and 3 are an elaboration or refinement or clarification of Moran, because it was not simply whether the contract was open-ended, but you look to see the purpose and nature of the work, which is essentially our ground.
The work or of the supply?
Of the supply of work. So if I may take you to the first case, it's in the second authorities bundle behind tab 33. It is Moran, and it's important to see the factual background here. So if I could take you to page 602, the third paragraph. The claimants were all employed for many years by the first respondent. They were placed with the second respondent. The job description of cleaner, starting date 1987, place of work was Courtaulds at Spondon in Derby. He and the other claimants worked there for many years until they were made redundant in late 2012. Now, at paragraph 8, one sees that the contention of the first respondent is that, put simply and by reference to Regulation 4, such was the length of the arrangement that it cannot be temporary. And then at paragraph 9, Mr. Williams said that his argument was not based on the length of the arrangement, but rather on the fact that it was indefinite. And what we submit is that no argument was heard in Moran for the proposition that temporary was short-term. Now, paragraph 16 on page 605, one sees the reference to the Collins English dictionary, the various definitions there. We have the latest Oxford English if you wish to see it. But temporary, not permanent, etc. And then at beginning at paragraph 18, there's reference to the agency workers regulations. At 607 to the directive. And then at 609, we come to the first submission, which is the only one that's relevant for our purposes. Paragraph 40, the submission was that the employment judge fell into error because he interpreted temporary to mean short-term. Then paragraph 41 sees some force in that criticism. In the end, I don't accept it. Not entirely clear what interpretation the judge was giving to the word temporary. Not helpful in adopting the dictionary definition because it in fact has two meanings. Word temporary can mean something that is not permanent, it can mean something that's short-term, fleeting, two are not necessarily the same. For example, a contractor...
So, well, if you're just to read through the para, we'll read it for ourselves.
It's really the next sentence that I did wish to comment on.
Which one is that then?
And then ask you to read the rest to yourselves. For example, a contract of employment may be a fixed duration of many months or perhaps even years. And in our submission, what that demonstrates is that in Moran, the EAT was not anticipating that there would be years-long contracts found to be temporary. If I could,
isn't it anticipating the exact opposite? Perhaps even years.
Well, what we say is that he's not anticipating that such would be for years. If you could read down to the end of paragraph 42, please.
Of course, thank you.
And then the first sentence of paragraph 50, where he summarises the point. So, insofar as this suggests...
So just before you make your submission on this, you rather skipped over the references made to the directive. But that, insofar as, which I think he did, Mr. Justice Singh decided the point. Was he not bearing in mind, I didn't say so explicitly, but he's just been over it, the use of the word temporary in the directive and what it means? If we look particularly at paragraph 34. Maybe if you were to come back to that, then please, I won't take you out of order. But
he set it out, but he didn't, in our submission, support the proposition that temporary means not permanent or is a fixed term or subject to a condition by anything.
No. Well, all right. We needn't worry about. I just thought it was a convenient point to raise it.
Yes.
At the stage at which to raise it. Ultimately, we needn't worry about the extent to which it featured Mr. Justice Singh's reasons. But as you know, it does feature Mr. Ford's reasons.
Yes.
And perhaps you're going to deal with it in that context.
I am going to.
I see. Very well.
Come back to it. But if I may, just before we go on to Brook Knight, take you to page 12 of the first authorities bundle. To the fixed-term employees' prevention of less favourable treatment regulations, which, as you will know, is made under the equivalent directive. And
I didn't know that, but yes, so fine.
there you see at page 12, fixed-term contract means contract of employment that under its provisions determining how it will terminate in the normal course will terminate on the expiry of a specific term, on the completion of a specific task, or on the occurrence or non-occurrence of any other specific event. And we say that if it had been intended to link the definition of temporary to it fixed term or the expiry of a condition, it could easily have said so by reference to the fixed term workers regulations. So the second EAT authority is to be found in the second bundle of authorities at tab 37. It's an unreported decision of Her Honour Judge Eady, as she then was.
I have a ban in this court on the phrase as he or she then was.
Okay.
You'll know who people are.
Absolutely. In this rather small employment law circle, we certainly do. But page 682, you'll notice that the respondent was not legally represented. In fact,
sorry, you're getting a bit fast. Page
it begins at tab 37, 681.
Yes, thank you.
I was just saying that neither side in this one were legally represented. So here you have at paragraph 3 on page 684, the respondent is a security company which employs security guards on what are described as 0 hours contracts at a variety of sites in London, usually at the mighty site at Citigroup headquarters, although there was evidence the respondent also supplied guards on an as and when basis to another company called Wilson James. And then to get a flavour of how the contract worked, would you be kind enough to read paragraph 5, please?
Yes.
And then paragraph 7.
Yes.
And then paragraph 14, one sees that the respondent argued that the claimant was a permanent worker for the end user to which he had been subcontracted to work on an indefinite basis. So this was an open-ended contract. And then the three grounds of appeal are that claimant couldn't be permanent if working on a 0 hours contract, in focusing on what the contract said rather than what the employee actually did, and in giving weight to the claimant's relatively short service. And then they set out the, or rather, Her Honour sets out the claimant's case. Then there's some discussion at beginning at paragraph 20. If you could be kind enough to read that paragraph, please. And then paragraphs 22 and to 24.
Yes.
And then crucially at paragraph 25, she says, on the whole, I agree with the respondent that the terms of the contract will not necessarily be determinative of agency worker status. The focus under Reg 31A is on the purpose and nature of the work for which the work is supplied. Is it temporary or permanent? And that, we say, is a refinement of the pure water of the Moran principle. And that's something that we see again in Angard, but is not reflected in the Lutz decision. If you then kindly read paragraph 26. So at the end of paragraph 26, the tribunal's finding that the claimant was assigned on an indefinite basis to carry out particular ongoing work. He was rather used as in this case, as a cover guard. And the judge says that finding was, in my judgment, fatal to the respondent's case. So that was the issue that determined it. She then looks at a whole series of other issues and says, in the penultimate line on the page, these were all, therefore, matters to which the ET was entitled to have regard, but the most significant part of its reasoning was based upon its finding as to the nature of the work done for the client, such as Mighty, and specifically as to the nature of the claimant's role as a cover security guard. And of course, in the Lutz case, there's no sense of cover. This is integrated into the establishment. Now, I emphasize this because in Mr. Lutz's skeleton argument, which is in the core bundle at page 1 153. That's divider 8, page 153. At paragraph 50, Mr. Ford deals with some points that we'd made, and then in the last sentence says temporarily is about time alone, and that's simply not the case. As one can see, it's a whole series of issues, particularly as to whether the work is, to put it in an overall word, precarious, as opposed to, as in the Moran case, regular. Now, the third case is Angard, to which you've already been taken. So that is at Authorities Bundle 3, Divider 41. If you'd be kind enough to go to page 759 at paragraph 7, one can see that Angard is a company in the Royal Mail Group with over 17,000 employees, a very big operation. And it says they are employed to provide a flexible resource to work for Royal Mail at its centres throughout the country. If I could just ask you for your notes to look on page 760 at paragraphs 14 and 15, not to read them now, because that's within the tribunal's judgment. And then we see and also paragraph 39 on page 762, which is also within the tribunal's judgment, just to get a further feel for the facts. One then goes to page 763, where there's extracts from Moran and Brooknight, and then the arguments, and then we come to the discussion and conclusions, beginning at paragraph 43 on page 770. And if I can specifically draw your attention to the way it's put in the second part of paragraph 44, that requires the tribunal in particular to make a finding of fact about the basis on which the worker is supplied to work for the hirer, and then to decide whether the supply to work on that factual basis amounts to a supply to work temporarily, applying the guidance in the authorities. And we submit that that, along with other paragraphs in this judgment, are against the proposition that my learned friend Mr. Brown puts, that what one is looking at is the contract between the hirer and the employment agency. One is looking at the basis on which the worker is supplied to work for the hirer. Now, the background of what that contract says may be of some limited relevance in looking at the overall facts, but it is one is looking directly at that relationship. And then paragraph 45, again, he talks about directing attention to the basis on which the worker is actually placed, designated, directed, or sent to go and work for a hirer on one or more specific occasions. And he effectively repeats this at paragraph 46. And then at 47, he looks at the word supply and the word assignment being defined in the regulations as well. And then at paragraph 48, he looks at the extent to which you consider the contract, and he says it's a good, the initial contractual documents, part of the evidential and factual matrix.
Well, isn't he introducing a new topic at 48, which is the contract between the agency and the worker, which rather suggests that the contract he's been talking about previously is the contract between the hirer and the agency. Well, and you might think that the basis on which the agency supplies a worker to the hirer will be set out in the contract between them, at least as a starting point.
But my lord, I can see where your lordship is coming from, but we say this is the first reference to the contract, so he isn't diverging from what he was saying before. He's asking where the actual contractual document fits into this picture. But everything that goes before is looking at, if I put it more broadly, the relationship between the worker and the hirer, not the relationship between the hirer and the agency. And so he moves from the contract to paragraph 50 to communications or documentation between the agency and the worker may well cast significant evidential light on supply. And then paragraph 51, the issue for the tribunal is not whether the overarching relationship between the agency and the worker is temporary or permanent. It's you look on a fact-sensitive basis, although he says that in paragraph 52, the documentation at first may give all the particulars of supply. And then at the end of paragraph 53, he says, if the worker is in fact then supplied to work for a single hirer on an open-ended basis, that supply would not be temporary. So again, he's looking at the relationship between agency and the worker and the assignment. And then at paragraph 54, at the penultimate line, he says, ultimately, the question for the tribunal is what was, in fact, the basis on which the given supply or supplies were made. And then at paragraph 59, all that said, at the end of the day, to repeat, what matters is what, in fact, happens in practice. And in a given case, that could change. And just the final thing I wanted to point out, if I may, is paragraph 66, where and one of the grounds of appeal was about guarantee of timing and duration of each assignment. He says the tribunal rightly directed itself that it had to consider the nature of each supply. And we respectfully submit that must be the supply as between the employment agency of the worker. So I'm sorry I've taken that at pace, because it is a very important part of the picture, and in our submission makes it clear that one is looking at the basis, whether it's precarious nature of a contract or otherwise, and makes it clear that the tribunal should not be beguiled by the nature of the contract itself. So, my lords and my lady, if I may take you to the way in which the tribunal here decided that Mr Lutz was supplied temporarily. If I could first take you to the core bundle, page 290, paragraph 102, because the tribunal begin their consideration of what is temporary work.
Sorry, which page did you say?
Page 290.
290.
Yes. Paragraph 102.
Yeah.
So this is where the judgment starts on temporary work. And the judge said that he's taken careful account of the submissions founded on Allenby. And as is common ground between, I think it's probably the only thing that's common ground between the three of us, is Allenby has got nothing whatever to do with temporary work or the agency workers' regulations. And he not only says that as the careful account that he's made of them, but he then at paragraph 103 and 104 makes some findings on it, which have got nothing to do whatever. Now, I accept, of course, that as Mr. Justice Singh put it in a case, we're not marking an exam, but one has to be satisfied that the reasoning of the judge is valid and rational. And we submit that, I'm afraid to say, that this judge was not laser focused on what the issues were. He does then, at paragraph 115, after having referred to the three relevant cases, paragraph 115 on page 293, say here there was a fixed 5-year term, it was not indefinite, that's the passage I've already read. Paragraph 17, somewhat...
117. Yeah.
Paragraph 17 on page 270.
Oh, I see.
Because what's happening is that the judge had effectively set out his conclusions before coming to the reasoning. That's why it's a little unorthodox to go back to paragraph 17. But he says that in fourth line, as Mr. Ford pointed out, a 5-year posting is in EU law temporary. I reject the argument that temporary only short term, such as cover for another. The word temporary stems, of course, from the Latin for time. This was a time-limited appointment. That in some cases it was replaced by another time-limited appointment. Does not make it cease to be a time-limited appointment. So in our submission, the tribunal wholly ignores what we would say was a refinement of the definition of temporary, looking at the basis, the purpose, the nature of the work in the Brooknight and Angard cases.
Were those submissions made to him? That is to say that Brooknight and Angard represented a refinement or qualification of what you could get from Iran.
I can't remember whether I used those specific words, but we certainly made submissions that you looked at you should look at the nature and purpose and basis of the employment. And then finally, one sees a sort of mixture of conclusions and reference from the cases in paragraphs 117 to 119. So what we submit is that the tribunal simply did not address the broader issues, which were certainly put before them. So, my lords, and my lady, if I can now come on to what are essentially 4 submissions as to the way that you should address grounds 1 and 2.
Just before you do that, and you may say it's what you're about to come to or coming to later, you've taken us to the decision of the ET, and I know it's orthodox to say that we ought to be really focusing on the ET rather than the EAT. The EAT basically reinterpreted the ET's reasoning, or not reinterpreted it, but elucidated it from the rather confused structural way in which it was put together, and satisfied itself that the judge had in fact asked the right questions and all the materials were there to support the answers. Are you going to show us why that exercise was wrong?
Yes, I'm happy to do that.
Only if you want to, but I mean, the EAT did a rescue job, you might say, on the ET decision. And if you're going to say the rescue doesn't work, it would be useful to show why it doesn't work.
Yes. Well, we say that it's not really appropriate for a rescue job to have to be done. But I understand.
In that case, you've poured cold water on a large number of my decisions in the EAT. It's the job of...
I won't pursue this one any further.
No, but realistically, you do get cases where the Employment Tribunal gets in a muddle about structure and so on, but where you can see that despite the muddled way in which it's expressed itself, it has fundamentally addressed the right points and reached a sustainable answer. Or sometimes you can say, even if it hadn't addressed the right points, on its own findings, there was only one answer.
Yes.
And both those techniques can be used. I forget which techniques were used here, but a mixture of both, I think.
Yes, well, if I could just very briefly take you to page 206.
Yes.
This is the statement of principles that the judge extracted from the previous decisions, on which she then...
No, we're now in the EAT.
Yes, that's what you wanted me
Yes, absolutely, yeah. Fine.
to go to. Sorry.
No, that's fine. You're doing what I asked you to do. I just for a moment lost my orientation. Yeah.
Page 206. I should say that we agree with all of these, except for Roman 2. And we say that if you put it in your terms, she hasn't rescued the tribunal judge, because this is wrong. It is not simply looking at whether it's terminable on some other condition. And Brooknight and Angard are not authority for that. The only other thing that we would say is in relation to Roman 4, where she says the focus is on the purpose and nature of the work. But we say that she doesn't then put that into force. Now, my lord, I've been handed a note by Mr Ford that he needs a 2-minute break.
Yes.
I don't think he's going to concede.
We'll have one.
Thank you.
Literally 2 minutes?
Yes.
Thank you, John.
Okay.
Of course you can go.
You're ready? We can start when they're ready.
Yes, thank you, Mr. Bowers. We were on paragraph 120, and you were saying you broadly agree with it all, except you didn't agree with little Roman 2.
Yes.
You had also made a submission which I didn't note about little Roman 4.
Well, that although she refers to that, it wasn't something that she then analysed in the decision, namely whether the tribunal had looked at the basis and purpose and nature of the work. And I can illustrate that, please, by taking you to paragraph 201, where she says that it's important not to lose sight of the question the tribunal is required to answer, namely whether the supply of the individual was on a non-permanent, terminable upon some other condition being satisfied, or an open-ended basis. References to the tribunal assessing the basis are explicitly for the purposes of answering the binary question. Now, the way we put it, my lords and my lady, is that if that were the case, Angard and Brooknight would have been determined on as being permanent as opposed to temporary. What made them temporary was indeed the basis of the work, the cover, the 0 hours contract. The relationship was permanent and open-ended. So, my lords, may I make our submissions? The first being that the Moran conclusion about temporary not being short-term is contrary to the wording of and purpose of both the regulations and directive. What we're looking at are flexible forms of working. If I could take you to the directive, which is in Authorities Bundle 1 at divider 15. You see in the recitals that recital 5 on page 152, in the introductions of the framework agreement on fixed-term work, the signatories, that's the employers and union side, indicated their intention to consider the need for a similar agreement on temporary agency workers and decided not to include temporary agency workers in the directive on fixed-term work. So there was a dividing between that. And then recital 9 on page 153, the last 5 lines talks about the European Council endorse the agreed common principles of flexicurity, which strike a balance between flexibility and security in the labour market and help both workers and employers to seize the opportunities offered by globalisation. So this is about precarious work, it's about flexible work. For your notes, can I ask you at some stage to read recitals 11 and 15, but take you to...
Hang on. Well, not just for our note, isn't 15 crucial?
Indefinite duration, general form of employment relationship. Permanent contract provision should be made to permit exemptions from the rules applicable in the user undertaking. So,
well, surely what they're saying is that
they can be exempt.
Well, what I found helpful in their thinking was that employment contracts of an indefinite duration are the general form of employment relationship. If you have a permanent contract, which is an indefinite contract, they don't need protection.
Yeah.
Because that's fine. So this is concerned, the guiding line that comes out of 15 is that the people who need protection are people whose contracts are not indefinite. And that's very similar to what the message you get out of 5.
Yes. But this is about protecting precarity and flexibility, not protecting permanent employment or long-term employment.
It's contrasting permanent, i.e. indefinite on the one hand, with temporary on the other. And it envisages that between them, those two occupy the whole employment space, doesn't it?
Well, no, we would submit not, because as Mr Brown has indicated, there's a whole range of employment relationships, and we would submit that what the directive is about is flexicurity and protecting precarious employment. And I re-emphasise.
You keep saying that, but
Angard and Brook.
this isn't what. Just show me where it talks about precarity.
Well, that's my word for flexicurity.
Well, I've never heard of flexicurity before.
Well, it's it may be a translation of the French or the Greek, but it's the
Greek.
Well,
You're not in front of Mr. Justice Burton now. I remember having a discussion with him about a European directive. He asked to see the Greek version. That did slightly throw me.
I'm sure you had it available. But recital 11 also talks about reconciling working and private lives. But I mean, I do emphasise that if we were just looking at whether there was a permanent relationship, Angard and Brooknight would have been decided in favour of the employer respondents.
Well, I mean, there's 2 points about that. You may or may not be right about that. I'll have to think about it some more. But we're the Court of Appeal. If they got it wrong, that's their problem. As a matter of principle, suppose there was no authorities and I was looking at the directive and seeing what distinctions the directive was drawing. The moment, it seems, as my Lord put it very succinctly, it's drawing a distinction between permanent and indefinite on the one hand, permanent stroke indefinite on the other hand, and limited or limited on the other.
Or short term.
Well, he didn't say that, and it doesn't say that.
No, it doesn't say that, but in our submission, the natural meaning of temporary, which is not defined by either directive or regulation, so that it is effectively left for construction. The natural meaning of temporary is short term. I mean,
well, you say that. Sometimes it certainly is. But it didn't always that way, and that's why we're looking at the recitals to see the sense in which it was being used by the directive.
Yeah. Well, I can't take it any further than I.
No, I do. Obviously, I don't want to suggest I made up my mind. I feel the pull of course, of the point. How can 5 years be temporary? But you have to think about it. You have to go behind your initial impressions. Anyway, there we are. Thank you. I see exactly how you put it.
Well, my Lord, let's take it away from this case, which is 5 years. If it's fixed-term contract, it could be a contract for 10 10 years,
Yes.
20 years.
20.
So,
lifetime.
and in our submission, nobody would realistically say that this directive was intended to cover that. And
Well, can I just make another point? You may say this comes into the next stage of the argument. The focus seems to be on the 5 years, and I see why it gives a nice clean answer to this, if it's right. But the view could be taken, if you look at the evidence as a whole, these contracts were, sorry, these supplies were understood by all concerned to be time limited. In another sense, you're only actually supplied when you're rostered. Rosters, I've forgotten my notes and the facts, occur on a 4-weekly schedule, or maybe, it doesn't matter. You're not rostered for the whole 5 years. And at the end of one roster period, you're not supplied until the next roster period. And there's no guarantee that you will be. We're told that in recent years, apparently because Ryanair has been so busy, he was actually, but that wasn't the deal.
Well, my lord, that would be a very narrow basis to look at this. And significantly, it's not the basis that has ever come from the claimant side.
Well, we'll see whether Mr Ford wants to jump on this bandwagon.
Well,
but cases do sometimes develop, even occasionally. Much more often, the Court of Appeal thinks it sees a good point that nobody else has seen, and it then turns out there's a good reason why nobody's seen it. But sometimes, as cases develop, more thinking goes into it. It's discovered there are other ways of putting it.
Well, I'm sure
they've got to be within the confines of the findings of fact.
And in our submission, it would be quite wrong to allow an argument that has been eschewed and open to the claimant to be taken for the first time in the Court of Appeal, not least because if that argument had been put, we would have wanted to put in different evidence about how, further evidence about how the rosters were structured.
Just tell me though, I forget whether there are findings about this, but if not, it must be an uncontested fact in itself. What period do rosters cover? 4-week period?
4 weeks, yeah.
Sorry?
4 weeks on.
They're published for 4 weeks, but they're done for a year.
They're done a year in that.
The off days are done for a year.
Yeah, well, thank you. So each roster covers a 4-week period, but they're published on a rolling basis, 12 months in advance?
Yeah.
Okay, thank you.
So in our submission, now can I just take you back to the James case in volume 2 of the authorities bundle at tab 26, because we do wish to adopt the point that fell from Lord Justice Mayles about Lord Justice Mummery, who is of course an expert on this area, not seeing 3 years as remotely to be described as temporary. You know the background facts, but if I could take you to page 413, paragraph 1.
Sorry, I should get one back.
Divider 26, page 413.
Yes.
One sees that Miss James had performed paid work for 3 years, and then...
Sorry, where are we seeing the facts? Yeah, sorry, I thought you said Mr. James, but
No, Mr. James. And then at paragraph 34, talks about a continuous period of 3 years provided services. And then at paragraph 44 on page 422, the sixth line down, she could hardly be described as a temporary worker. And we say it's only a throwaway remark, of course, I accept, but that is what most people would consider. Still less a person on a 5-year contract, which without exception, an offer was made to extend. Now, things have developed in the European Court since the 3 cases. We've had 2 cases where the length of time has been seen to be an important factor in whether work is temporary. If I could first take you to JH and KG, which is in the 3rd authorities bundle at tab 46. I wasn't going to take you to the Advocate General, but simply to give you 3 paragraph numbers from that. And they are.
which Advocate General? Oh, well, this is Advocate General Clarkson.
Yeah, it is. Just for reference, please, paragraphs 51, 56, and 72.
You'll forgive me if I do look at them, actually.
Yeah, of course. Of course.
It's a particularly authoritative source in this sort of case. Yeah, see in the footnote we get French and the Italian, but not the Greek.
Yes, that's right.
Green is your sidelining, is it, or is that Mr.
It's our sidelining, yes.
Sorry, forgive me for taking this slowly, but
No, not at all.
slightly ambiguous use of the word fits in the footnote at 22. Anyway, so I've read 51, 56, did you say in particular?
Yes, 56 and 72. And it's that phrase in 72.
I haven't got that far yet, sorry. Yes, sorry.
this phrase that successive assignments that taken together exceed a duration that can reasonably be regarded as temporary, that we rely on.
Of course, the effect of that is to remove. I mean, what would Advocate General Sharpston or the EU legislator think of a situation in which there was very long employment of an agency worker, but on terms which were inferior to those of the directly employed staff?
Well,
you would think it very surprising that those people shouldn't have the protection of the requirement of equality, whereas the temporary workers, the temporary agency workers do.
well, maybe there should be further legislation on this, but the question is, does it fall within agency workers' directive and regulations, both of which use the concept of temporary?
Now, I do see that, but what you're saying is that contrary to what the Employment Tribunal and the EAT and indeed Justice Singh thought, the Advocate General at least thinks that even though the core concept is maybe fixed, a limited term, let's use that word, nevertheless, there's also an element simply of duration.
Well,
if it gets too long, it can't be temporary.
That's clearly what...
I know what she's saying, yes, I'm just trying to...
No, sorry, I was going on to say, my lord, that it's clearly what the CJEU say as well at 887. What I was going to do, because I'm conscious of the time, I was going to give you paragraph numbers, but just ask you...
Well, it's up to you. I mean, on your timetable, how long have you got when you supposed to
well, I've gone beyond, although we did...
Well, we can sit a bit late. Well, okay, give us... I agree, but probably having looked carefully at what Advocate General Sharpston said, we can look much more quickly at the... 887, which paragraph numbers are we on?
Well, it begins at 40, where it sets out the purpose.
Yeah.
Then paragraph 47. (51 to 55). But the key passage is really 67 to 69.
It seems to me that although the Advocate General and the court are using the word temporary to mean short term and say that a point will come when the term is of such duration that it can no longer be regarded as temporary, they are doing so to achieve the opposite result from what you're seeking to achieve. You want to say that if the employment is not temporary, then the worker has no rights under the relevant provisions, whereas what the Advocate General and the court are saying is that if it is not temporary because it's really permanent, then that is an abuse and it should be treated as permanent.
Well, my lord, it does come in the context of an application that there's been an abuse of the provisions, unlike in the Lutz case. But we say that the decision, the they're two sides of the same coin. They're inherently interlinked. And the definition of temporary is clearly here said to look at how long the relationship was going on, albeit I do accept that the actual facts come from an application about abuse.
But the consequence of applying this reasoning to our case is that Mr Lutz should have all the rights of an employed pilot.
Yes, but in our submission, someone in a precarious position on a 0 hours contract, providing cover, one can well understand if they're called on, called off on the day, one can well understand why they need protection under the Agency Workers Regulation. If someone is employed for 10 years and has got protection under a 10-year fixed term and has entered into that 10-year fixed term, then in our submission, the policy does not support that, still less the actual proper construction of it. And
so is your case that if Mr Lutz had brought a claim under the fixed term contract regulations, he would have succeeded?
Well, he possibly, and indeed you'll recall that if someone is on a fixed term contract for 4 years or more, they may extend that to be a permanent contract. Perhaps I should show you that. It's in bundle 1 at divider 3, page 12. So there is protection for fixed term employees. They don't have to apply for it. And Mr Lutz hadn't, although he hadn't got that far. So Regulation 8. This regulation applies when an employee is employed under a contract purporting to be fixed term. Sub-regulation 2, where this regulation applies, the provision of the contract that restricts the duration of the contract shall be of no effect, and the employee shall be a permanent employee if the employee has been continuously employed under the contract mentioned in paragraph 1A, or under that contract is taken with a previous fixed term contract for a period of 4 years.
Okay, well, we can look at the details of this, but you're saying that the model is that if it becomes fixed, but the problem, of course, but he's not an agent. That doesn't work. Doesn't extend to agency employees.
No,
It
but
falls
I'm saying
between
by
two
analogy.
stools.
I'm so sorry, my lord.
Well, the analogy wouldn't work, would it?
Well, it's if it depends who is employed by. Which
Yes, I know. Well, that's you're basically saying there's. I think you have to say there is a lacuna in legislative protection.
Yeah.
If you're being employed on a series of short-term fixed contracts and are an employee, you can become a permanent employee. But if you're employed and if you're a short-term agency employee, you can have the same rights as full-term employees as long as the engagement continues. But if you are long-term, long-term and fixed-term agency employee, nobody has thought to protect you.
Unless there's a gender element, and then
Oh yeah, all right, but that's just no. But assuming this is the only element.
or some other.
Yes. But that's just evaded.
Well, I'm afraid, my lord, that is
what you have to say. No, and you may be right. I mean,
what it comes to, but I think one can't get away from the fact that in J8 there is a clear consideration of time, and the same in the Daimler case. Again, I was going simply to ask you to read parts of it. I'm happy to take you to it if you...
Well, I mean, I think we'll have to see whether, when Mr Ford gets his feet, we'll see what he needs. But he lost 5 minutes as we gave him a break.
Yes.
But we can set a bit beyond 4:15 if necessary.
Okay.
I'd rather
So,
not take this as a rush.
yes, so the Daimler case should be...
We've got it, yes.
So, it's the key paragraphs of 48 to 63. We can...
Sorry, we're looking at the Advocate General.
No, the judgment of the court. I can give you...
Well, I've only got the judge with the opinion of the Advocate General. You haven't got the opinion of the judge, or is it... is it in the bundle? I'm sorry, I just went to it because I knew we had it loose, but is the court in the bundle?
I was told it was 1,098 in the bundle.
Okay, well, let's have a look.
At the back of Divider 3. But we've got further copies.
Well, if it's in the bundle, we don't need further copies. Oh, I see. Right. No, well, it isn't. Did someone think the bundle had been updated?
Well, we have sent copies to the court, apparently.
Oh, I think, yes, I'm sorry. It's a precarious way of doing it, I'm afraid, because it depends on us printing out what was sent and so on.
Yeah, actually, I seem to have it loose, so I wonder whether my...
You've got the court loose?
Yeah, apparently.
Okay, well, I've only got the Advocate General loose. Anyway, we're getting it, so... Perhaps you're more diligent in getting your clerk to print it out.
These are all of the new authorities, including my learned friends.
Okay.
So I think really what I need is paragraph 57.
Page?
Well, the internal numbering is page 13 of
Yes,
the
bundle. These are bundle numbers.
Yes,
So.
1,110.
1,100 and something.
1,000. 1110.
1110.
1110.
Got it. Okay.
And in paragraph 57, open to member states to set a specific period beyond which an assignment can no longer, including where successive renewals go on for some time, be regarded.
Well, shall we not read it more quickly to ourselves? How much of it do you want us to read?
Well, I'd like you to read, really, to get the full picture, 49 to 63, but the key one is 57.
Well, I think the pragmatic answer to this is I suspect, Mr Ford, you're going to be taking us to this authority in some detail.
Oh, Mr Britton.
Well, we won't spend time reading it now, and I suspect we will read it overnight.
Yes, thank you.
Mr Brittenden will take us to all the bits of it. You can reply on it if you fit it into your reply.
But thank you very much. Can I then move on?
Just before you do, is this one of those post-Brexit cases that we're not bound by?
I'm not sure. I'd have to. It's too.
I see Mr. Ford nodding.
I think it dates from earlier, so I'm not sure. Okay. Oh, I see. Sorry, the judgment.
You want help?
Yes, please.
It's after IP completion date, which is the 31st of December 2020, I think. But that means you can look at it only if you consider it relevant. And that's sections 6, 1 and 2 of the 2018 Act. So it's not binding because it's not part of retained EU law, but you can look at it.
But the legislation on which it is commenting is part of, well, it's not part of retained
Yes.
EU law, it's domestic law derived from the directive.
Yes, but you may recall the Act says it also defines retained EU case law and says that means ECJ decisions before.
Yes, but my point is it's likely to be relevant because
Yes.
it is commenting on legislation which is still current.
Yes, but I think
It's not
strictly
it's not binding.
no.
And it-
Whereas the same is not true of Daimler, is that right?
Well, no,
I don't mean
You mean
Daimler,
J8?
I mean
correct. Yes, I'm pretty sure IP completion.
well,
date-
let's when you or Mr. Britton get to this point, you can deal with it. Yeah.
So, my lord, as your lordship said, you're not bound by the EAT cases. And what I want to put forward, finally, is a proposition as to what are the tests for temporary working. And it's fourfold.
Is this in your Stellis?
No, it isn't.
No problem. We'll just take it down dictation speed then.
I'll do it as quick. Yeah. Firstly, the duration of the assignment. And we accept that fixed term is more likely to be short term.
This is all part of your point, first point.
Yes. But if the fixed term is for, say, 30 years, it's definitely not short term. And this factor would be decisive.
Yeah.
Secondly, tribunal should look at the purpose of the work for which the worker is supplied.
Yeah.
Temporary stroke short-term work will usually satisfy the hirer's need for flexibility. For example, changes in demand. Thirdly, the nature of the work may say something clearly about its purpose.
What does that mean?
Well, for example, if a role is to provide cover for permanent employees who are absent, that points strongly to the purpose being to meet the need for flexibility. But there could also be seasonal fluctuations in demand, such as originally envisaged in the agreement between Storm and Ryanair, but as we know, that was superseded. The fourth issue is whether there is a guarantee that work will be provided. So if there isn't, as in the 0 hours contract of Brooknight, then that will tell in favour of temporary, as it did in that case. Now, what I propose, my lords and my lady, is just to locate other parts of our skeleton argument now, rather than develop points, given that and also Mr Sheridan needs to deal briefly with ground 3.
I'd forgotten that Mr Sheridan was dealing. What's he dealing with?
He's dealing with the...
well, I think you really are. Well, we've got your skeleton.
Okay, that's fine. I'll sit down.
Yes, right.
Thank you.
Mr. Chairman, what are you dealing with? Sorry, that sounded very unwelcoming for a junior in the Court of Appeal, but I've forgotten.
Thank you. No. My Lords and Lady, thank you very much. So ground 3 effectively deals with disposal. So what we say is if ground 1 or 2 succeed, then on the facts, the only conclusion which this tribunal could have reached properly was that Mr Lutz was not supplied to work temporarily, and therefore we should not be looking at remission.
The test is clear enough. If it's the only possible outcome on the found facts.
Indeed.
That cuts both ways, of course.
It does indeed, my Lord. But we say that it's very clear on these facts, and given timing, I can hopefully attempt to deal with all of this extremely briefly.
Okay.
So the first point is if ground 1 succeeds. So if consistent with ground 1 temporarily means short term, then Ryanair says Mr Lutz plainly was not supplied to work temporarily. Mr Bowers has just set out the test to be applied. I don't propose to go through that in great detail, applying it to the facts. What I do propose to say is as to duration, he was the contract between Mr Lutz and the agency provided for him to be supplied for a period of 5 years. So even if it is the case that the contract terms are determinative, or even if they reflect the reality in practice, and that's as far as you go, we say it's not. But if you've just looked at the contract, 5 years is not short term.
Well, hang on. Where's the contract saying Mr Lutz will be supplied for 5 years?
That is the contract which Mr Bowers' case took you to between Mr Lutz, MCG, and Mr Lutz's service company, Dishford Port. Schedule 1 provided for a period of 5 years.
Yes, but during those 5 years, all that he will have is 450 flying hours a year. That could mean that he was
That's a minimum.
employed on and off during that year. He could be applied. He could fly flat out for 6 months and then be laid off for 6 months.
Well, my lord, that gets into the point which you raised with Mr Bowers about the possibility of each flight effectively being an assignment in its own right. And as he said...
Well, I don't think I said each flight, but I think I said each roster period.
Each roster period perhaps being an assignment. But as Mr Bowers said, that is not the way that the argument was put below. It's not the way that we've conceptualised this to date. Nor did the tribunal, nor did the EAT. So if it is all one assignment, then it is a 5-year assignment if the terms of the contract are determinative. Now, we say they're not. We say you have to look at the reality of what happened in practice. And that is where the point about renewal after 5 years without exception comes in. So here, we say that in this respect, Angard and Brooknight were correct. They both emphasise the importance of not obsessing about the terms of the contract, but at looking at the reality in practice of the basis of the supply. And so, in reality, Ryanair submits Mr Lutz was supplied either indefinitely or putting it at its lowest for a period of at least 5 years, because if he wished his contract to be renewed, then it would have been. That's what the tribunal found. And if I could just briefly come back to one point which was raised with Mr Bowers' case, and this is a point which features quite heavily in Mr Lutz's skeleton argument. He emphasises, in relation to this ground 3, that his unchallenged evidence was that he understood that his assignment would last for only 5 years. And Ryanair accepts that. We accept that that was his understanding at the time. But my submission is that that is of limited, if any, relevance. And that is because Mr Lutz contends that Angard and Brooknight were correctly decided. He relies on the very paragraphs in those EAT decisions which say that you have to look at the reality And nowhere in those authorities is it suggested that what matters is simply what is in the mind of the putative agency worker, or even the mutual intentions of the parties, but certainly not the subjective intentions or the understanding of one of the parties. What matters is the basis on which the worker was in fact supplied in practice. And as was pointed out in Angard, paragraph 54, I'll just give you the bundle reference if I may. So that's Authorities Bundle 3.
Well, don't even bother, we know where Angard is.
I'm grateful.
We're short of time.
I'm grateful. Paragraph 54. Point is that the practice may change over time.
So we've got that point.
Another big point which Mr Lutz is going to raise is the need for certainty. And so the fact that in Angard the EAT acknowledged that the basis of the supply looked at in practice may in fact change over time is a powerful point to say that, well, there's some inherent uncertainty perhaps in all of this. And that was, in Angard, the EAT's conclusion, despite the fact that it noted that the claimants in that case were concerned about the need for certainty at the outset. And at paragraph 57, the EAT said, well, we acknowledge that, but... so, my lords, those are my submissions on just ground one and duration. Now, Ryanair's primary case is that you need look no further in this case than to the very long duration of the supply of Mr Lutz's services. So if it's at least 5 years, you
This
need
is the
look
point
no
you've just
further.
made, isn't it?
My lord, it is. I'm just going to say that.
So I don't want to be touchy with you. We are short of time, and
Not
you're
at
in an awkward position. You've been given. Can you just make the key points? Not
Yes, my lord. So the point is that Mr Bowers set out what we say is the test for temporary. Part of that is duration, which is dispositive in a clear case like this.
Yes.
If it's not, you go on to look at the context, and in particular the purpose and the nature of the work for which the putative worker is supplied. So I should briefly address you on that, not for purposes of ground one, but also, my lord, for ground two, because our ground two is, if we're wrong on ground one, it's all about purpose and nature.
Less context, make the points. Yeah.
My lord, yes. So the key findings of fact from the tribunal, you will have gleaned. There was a pool of pilots to support the expansion and contraction of Ryanair's services at short notice to deal with seasonal increases in flights. That is what the original MCG contract provided. The tribunal said no, that was no longer the case by the time that Mr.
Okay, I've got that point.
Lutz came on board. And the rostering pattern you've got, Mr. Lutz was rostered on the same basis as all pilots.
Yep, got that point.
That's accepted. So what that means is he's part of a pool of pilots rostered on the same basis, which means the purpose and the nature of his work was exactly the same as that of pilots who were permanent employees of Ryanair, namely to satisfy Ryanair's ongoing and indefinite need for pilots, not to supply Ryanair's need for flexibility. And there is no answer to that submission in Mr. Lutz's skeleton.
Well, don't worry about that. I want to know what your case is. Yep.
Well, my lord, I can probably sit down then and deal with the rest in reply. Because I've only got two further points, but they're both really knocking down points made in Mr. Lutz's skeleton.
Well, I think Mr. Ford is getting a bit antsy, and
I'm grateful.
though you've done it very nicely, these are points I think which we do have in mind, and as you say, you'll have the right to deal with it in reply. Thank you very much, Mr. Sheridan. Now, Mr. Ford, let me just. Yeah, we've got to 4:30. Yes. We've got to 4:30. Yes. We will go on to 4:30, just so that we're not on time for tomorrow.
I'm very grateful, my lord, and also I'm very grateful for the break you gave me. I'm going to be dealing with grounds 1 or 3 of MCG.
I get very confused as to which these grounds are. What points?
I'm dealing with the worker point.
Yeah, okay.
So that's whether he's a worker for the purpose of civil aviation or for the purpose of agency regs and charter. And Mr Britton is going to deal with the temporarily points.
Okay.
Now, just to say the structure of where my submissions are, but I'm only going to be able to deal with one issue today. First of all, I want to just lay out the headlines of our argument, the structure of our argument. And then tomorrow I'm going to go through the facts, look at the key ECJ cases, then say something about Storm Global and finish with the Charter and the agency worker regs. So all I'm going to do today, if you'll bear with me, is to give you 10 propositions that really outline our headline points. Now, to some extent, this is tantalising. Well, maybe not. Maybe not quite tantalising, because I'm not going to take you to the cases, but I'm going to tell you what our argument is. So the first proposition is it's not in dispute that the claimant was required to perform services personally under his contract with MCG. In fact, the tribunal found the dominant feature of his contract was personal service. See EAT paragraph 52, if I can just give you the references for now. So we know the substitution clause is a sham.
We don't need to worry about that.
That's gone. Secondly, it's MCG who paid him under his contract, and it was under his contract with them that he was entitled to 1 month off free of duties each year, unpaid.
Okay.
Thirdly, and we say this is important, it's not in dispute, as the tribunal found, that Mr Lutz was not an independent contractor, was not in business on his own account, and neither SG nor Ryanair was a client or customer of a business.
So basically, you're saying that he, if he's not an employee, he's a LIMB worker.
More than that, he falls within the very class that the regulations and directive are meant to protect, because he's not genuinely self-employed, or in EU terms, he's not an independent contractor. So he falls within the very scope of the protected class.
As defined where?
He's a member of flight crew. He's a member of, which is defined in both the directive and the regulations.
No, but sorry, in this particular respect, you say he falls squarely within the protected class. Where does it say the protected class are people who are not in business on their own account and for whom neither the hirer nor the contractor are their clients or customers?
It's a consequence of the directive applying to workers, but not to independent undertakings.
I see. Well, that's right. That's what I was trying to get at by saying
Yes.
LIMB worker.
Yes. So it's the fact that under the EU law, there is the binary distinction between undertakings on the one hand, independent undertakings, and workers on the other. That's constant in our skeleton at 34, not disputed by Mr. Brown. So in EU law terms, you're one or the other. You're either an independent undertaking, subject to competition law rules, or you're a worker, in which case you're not. You're then subject to the protection. And perhaps I can just give you the paragraphs in the judgment now to show you formally that is the case, that that's not contested. It's paragraph 6 of and 20 of the tribunal's judgment.
This is the Employment Tribunal.
Employment Tribunal. Sorry, paragraph 6 of the Employment Tribunal. Neither SG nor Ryanair were a client or customer of businesses. And you can look at the EAT 20 as well.
Okay.
And there's no challenge to the ET's finding at 104 that his independence was entirely notional that he was not employed, a self-employed businessman, nor to the tribunals at 1646 and 122.6 that he was not in business on his own account. Fourth, it is not in dispute that the relevant question is whether he meets or met the autonomous EU definition of worker and employment relationship. To confirm that's not in dispute.
Well, we were told it by Mr.
Yeah.
Brown this morning.
So, fifth, and I've already really made this point, when it comes to tracing the boundary in EU law between workers or independent contractors operating their own businesses, we know which side of that line he fell on. He's not an independent undertaking, but a dependent worker. And that brings me back to my class point. He falls within the very class the directive and regulations are intended to protect. Those who aren't operating independent businesses or aren't genuinely self-employed. So just to highlight what we say about Uber, if one just looks at one case, one extract now, which is at 71 in Uber at page 908.
So I was quite interested in getting to the end. You want to make this point now? Do you?
I just think it would be helpful. It's the only case I'm going to take you to. It's partly done as a bit of shameless toadying.
I'm all for that. Shameless toadying to whom?
You.
I thought so. It's not often that citing Uber is good for myself.
Well, I know it can also be painful, but
Okay,
in this respect, there was pain, but there was also
I
pleasure.
still think I was right, by the way. Now, where are we going?
We're going to paragraph 71. This is Lord Leggett framing the question that's going to be put.
Sorry, so I just want to find the bundle.
908.
It's bundle 3. Yep, okay, 908. Yep.
And he's saying, look, when you come to these cases, and Uber's about hard cases, about which side of the line people fall. He talks at 71E about the purposes to protect vulnerable workers and so on. The paradigm cases, he says, as an employee, and that here we come to the piece of toadying. He then cites you clearly elucidated by Recorder Underhill QC giving the judgment in the AT and Burn Brothers.
Yeah.
And you said at H, the purpose of, this is the bit he's approving, the purpose of the regulations is to extend protection to workers who are substantively and economically in the same position that is as employees. Thus, the essence of the intended distinction must be between, on the one hand, workers whose degree of dependence is essentially the same as that of employees, and on the others, contractors who have a sufficiently arm's length and independent position to be treated as being able to look after themselves.
Okay.
We know which side Mr. Lutz fell on.
Yep.
So the big question, the difficult question that arises in cases like Uber, has already been answered.
Yep.
And that's what Uber's about. Uber's saying, look, when you've got a hard case, how do you resolve it? Because in that case, of course, the drivers had a lot of independence. They didn't have to work fixed hours. This isn't a hard case.
But Uber wasn't about that. Uber was about who they were working for.
Who they're working for, exactly. And the issue of agency. That's the actual strict issue in Uber. So then we come on to the sixth and critical question, which is, on the premise, which must be correct, that he's not an independent contractor, he's a worker, who is the employment relationship with?
Yeah.
And we've got four possibilities, as we know. Could be with MCG or SG. Could be with Ryanair. Could be with the service company. or it could be with no one.
We can ignore the service company, can't we now?
Well, the service company's in the dustbin because, as you noted, it was held to be a fiction. But for the record of for your note, that's ET paragraph 75,
Okay.
EAT 136.
So 3 options really.
3 options. So, employed by no one. Now
This is all your point 6.
yes,
Yep. Okay. Yeah.
I hope it's point 6. Yeah.
Yeah.
So employed by no one. This would be the suggestion. He's a worker, but doesn't have an employment relationship. Now, it looked from Mr. Brown's skeleton as if he was suggesting it's probably Ryanair, but he's not actually said today that he's not suggesting no one is. But we say if this court would find he's a worker but employed by no one, that would fundamentally subvert the protected purpose of CATWA, the domestic regulations, the directive, the social right to paid annual leave, the health and safety purposes that underpin the directive, the agency worker regulations, the agency worker agreement, because effectively his right would be meaningless.
Well, agency worker is a bit different.
Well, I'll put that to one side and I'll come on to that tomorrow. But all the others, you would fundamentally subvert the purpose because you'd be saying you're a worker, you're a member of the protected class, you've got a right, but you've got no one to enforce it against. It dissolves. I mean, it's basic Hofeld stuff. He's got a right, but nothing to do. So we say that would be completely inconsistent with Uber. Because Uber is saying you approach these regulations purposively. The purpose of these regulations is to protect pilots who are not independent, genuine independent undertakings from working too long hours, from not getting annual leave, from having health and safety. So we say that's an improbable result that would render the social rights, and my lord and my lady, you'll recall how the Court of Justice always refers to the social right, the important social right to paid annual leave. It renders it illusory. 7th, it is no longer disputed that SG is a temporary agency worker within the meaning of AWR.
Who's SG, sorry?
Sorry, Storm Global MCG, I'm using the 2 labels interchangeably.
No longer disputed that MCG is what is a TWA.
Temporary work agency, yes, within the meaning of AWR.
Why is that relevant to the construction of the CAWTR?
Because I'll show you when I come to the facts tomorrow, but because in his skeleton, it's being asserted that all it did was provide, quote, ancillary payroll and administrative services. That's what Mr. Brown is saying in his skeleton. Now, when we look at the contract and other findings tomorrow, we say it's a pretty odd payroll company to whom you owe an obligation to work, and
who's the one who dismisses you at the end?
And who's the one who dismisses?
Yeah, okay.
So it's really just
it just seemed we departed slightly from where I thought we were.
Well,
these were all CAWTR points. But.
I told you it would be tantalising.
Okay.
I'll move on. I'll take the hint and move on quickly. But
okay.
The court may recall that before the EAT, there was an argument whether it qualified under the payroll exemption. That was dismissed by the EAT. There's a payroll body exemption in AWR.
I forgot on that, but
that was dismissed. It's not an appeal here.
Okay.
So
was that your point 8 or was that
7?
That was, okay. Yeah.
So 8, we say the real choice in giving effect to the social right is between MCG or Ryanair.
Yes.
And that's the coy hint we have in MCG's skeleton.
Yes.
It might be Ryanair. And that's where they raise their two matters about, well, he's actually subordinate to Ryanair. And also he's working for them. Saying, we meet neither of those. We're not the employer, implying Ryanair is. And that's where we say the argument falls apart. And I'll give you the headlines at this stage. And these are part of 8, but they're kind of sub-paragraphs.
Yeah, that's good. I'm liking it so far.
First of all, nothing in CAT-12, the aviation directive, says the individual must be working for the employer or be under its direction or control.
Hang on 1 second. Does refer to his contract, but you want to come to that later.
Yes, but refers to employed by.
Good, okay.
Secondly, and this is critical, when it comes to the autonomous EU concept, in a triangular agency relationship, both the EU directives and the consistent case law of the Court of Justice and that is both the EU directives and the case law of the ECJ.
Yeah.
And to highlight now, the cases are Allensby, Treedsrat, I've probably mispronounced that.
I think that's probably not a real name anyway. That's probably the name. Yeah, but it doesn't matter. But Treedsrat, I know the case you mean anyway. Yeah.
Yeah. And LM.
Okay. Both the EU directive and those cases, ... do what?
Show that the existence of direction and control by the hirer does not exclude an employment relationship with the agency. They hold that the only employment relationship is with the agency, even though the worker is assigned to the hirer and working under its direction and control. Thirdly, the directives and case law equally show that the fact of working for, in inverted commas, the agency, whatever that means, is not a necessary condition for a worker being in an employment relationship with the agency.
Sorry. So that working for the, quotes, for the
agency,
yes, I see.
Whatever that means, is not a necessary condition the worker being in an employment relationship with the agency. Fourthly, nothing in the directives nor the case law suggests that in a triangular agency relationship there is an employment relationship with the hirer or user.
So again, nothing in the
directives nor the case law suggests that in a triangular agency relationship, there is an employment relationship with the hirer stroke user undertaking. There, so far as I can tell you, we always got to be careful with the negative. There has never been a case in the context of agency workers where the Court of Justice has said the real employment relationship is with the person exercising de facto control and for whom you're working. No, all of them say you're looking to the agency for the employment relationship.
Got it.
So fifthly, really that's the same point. EU law is consistent and clear. Where an agency worker is assigned, the employment relationship remains with the agency.
Now, you needn't answer this now, but just to flag this up, I absolutely get how that works in what you might call ordinary employment relationship issues. But this is health and safety. And although rather oddly, this particular claim is actually just about the payment of money, that's parasitic on the substantive obligations, which are about the organisation of working time. So you will have to show us how it is workable to have a situation where the legal obligations to provide for working time, all the detailed arrangements about working time, can lie with an entity that has no power to produce those results.
Well, first of all, it's never been suggested here some sort of bespoke definition applies. It's never been suggested some bespoke terminology of worker applies because of the particular context of CAT work.
It may not have been suggested. I'm just trying to...
Oh, all right. Sorry.
I'm suggesting it.
The substantive right we're here concerned with is the right to paid annual leave.
But it would be odd if that right could be pursued against the agency, but the right to, I have to remind myself what the remedies are, but the right to have so many rest breaks, because I'm actually slipping into the ordinary WTR, but the same issue arises in the WTR, doesn't it?
Yes, yes.
Well, no, let's not slip into it because Regulation 36 makes it more difficult. Let's just look at some of the substantive obligations under the CAWTR. Seven. Where an employer, MCG, intends to organise work according to a certain pattern, MCG on your case, he shall take into account the general principle of adapting work to the worker. Without prejudice, he shall ensure that the pattern affords the crew member adequate rest breaks, take into account the need to ensure the pattern offers the crew member work that alleviates monotony or working at a predetermined rate. MCG can't do any of that.
Well, a similar issue arises under the other health and safety directives.
Yes, I guess it does.
And there, the European legislature has said the employment relationship is with the agency and those duties apply in full to the agency.
I see. Well, these are the cases you're going to show us tomorrow.
Well, that's the directive I can show you. Do you...
No, I don't want to know now. I just wanted to flag up. Because the bottom line is that's what I quite see the attraction. I'm an old-fashioned lawyer. I like your obligations to be against the person with whom you've contracted. Even if, I mean, nobody suggested it's a sham. We might, as an outsider, say it's artificial, but it is the relationship everyone has signed up to. So it would be odd, I quite agree, if the relationships under the regulations didn't correspond to those contractual relationships, or relationship agreements, relationships. But it's got to be workable.
You'll be aware of the Framework Directive in Health and Safety laying down all kinds of obligations on the employer and other daughter directives about organisation.
Well, that's fine. Don't try and do it at 425. No. I'm just flagging up that I'd be interested, speaking for myself, in being addressed on that, because that seems to me to be, I'm all for, if for purposive reasons we have to say, we have to find an employer, and it has to be someone other than the person who's actually organising the work. I just want to see how it'll work. You'll say it will. So,
yeah, well, and I do make one other point, my lord. Contrary to what you were told this morning, the Charter is directly and horizontally enforceable. Charter right to paid annual leave. So that is an independent basis for asserting our rights. The right to paid annual leave in the Charter.
So a fallback way in which we could decide this case, if you're right about that, is, well, we'll have to leave this problem about enforcement of the CAWTR obligations to another day, and who they're enforceable against.
But the Charter
but the Charter right...
that only makes sense against MCG, because it's a right to take annual leave, which his contract provides for, and it's a right to be paid normal remuneration. Now, the idea that it would be Ryanair that doesn't even know, well, they may know what he's paid, but Ned doesn't pay him, that obligation to pay him normal remuneration in respect of annual leave would be guaranteed and would be required on Ryanair is ludicrous.
Well,
perhaps I'm putting it.
I mean, the oddity, one of the oddities is if you look at the agency workers regulations, these problems are faced up to, and breaches of the agency workers regulations can be sued, can be brought by against either the agency or the contractor, and there's an apportionment mechanism.
Yes.
Deciding when you decide whose responsibility it is. But that mechanism has not been used in the working time regulations.
No.
Or these particular working time regulations.
But if you're wrong against me on CATWA, our fallback is the Charter is horizontal.
Yeah, okay, I've got the point.
And also, by the way, the Charter does guarantee the minimum.
Okay, don't trail points. You trail them as much as you need. Shall we stop there?
Can I just finish on my last point?
Okay, very quickly. Yeah.
So the criteria to determine.
Is this number 9?
This is subparagraph 6 of 8. So the criteria to determine whether whether you're a worker, whether you're a worker of the agency.
Sorry, I wouldn't have intervened, but I hadn't thought you'd stop.
No, just the very last one. The criteria to determine whether your relationship vis-a-vis the agency is an employment relationship or not brings us back to the boundary between independent undertaking and dependent worker. You look at the extent of the limitation of the worker's freedom to decide their hours, place and content of their work. Allenby. All to answer the overarching question, are they an independent contractor or not, to which we already know the answer.
Yes, but how does that answer the actual question, which is if they are a worker and not employed by nobody, who are they employed by the hire or the that's the big question.
That's exactly what Allenby is addressing. Allenby is addressing in a claim against the agency.
So I didn't know you'd even mentioned Allenby under this head. Sorry, what was this point then? I thought I got down the criteria to determine whether the relationship is with the agency or the hirer brings us back to the basic factors of whether he is
an independent undertaking or a dependent worker.
So what's that got to do? Oh, well, that's what you mean by Allenby.
Yes, and Allenby says when you do that, you look at the extent, in the context of a claim against the agency, you look at the extent of the worker's freedom to decide their hours, place and content of their work.
Okay. Well, I see the time. We got your points 9 and 10, and we'll sit again at 10:30 tomorrow.